Hey there, welcome back to my YouTube channel. I want to talk about one of the most common things that comes up in meetings and phone calls and public events and everywhere is the dreaded Miller Trusts. Yeah, the Miller Trust. Let me first tell you what it is, when it's used, and then we'll talk about some of the issues with it. A Miller Trust is a trust, but it's not a estate planning trust. It's not something that you would do beforehand. It's not what you would typically go see a estate planning lawyer to do. It is a Medicaid tool. It is only used when absolutely necessary and is done at the time of Medicaid application, not too much beforehand, okay? It is only used for Medicaid, and it is only used to hold income. So sometimes people will call me and say, hey, can I put my house in a Miller Trust or a CD in a Miller Trust to get qualified? The answer is no. The official name of a Miller Trust is a Medicaid qualifying irrevocable income only trust. Irrevocable income only. So the other strange thing about it is if you're listening across the country, there's a chance that your state may not require a Miller Trust. And a Miller Trust is only needed in those states that are known as income cap states, meaning that that state, under the federal Medicaid rules, has said there is a cap to the income that you can make and still qualify for Medicaid. However, you can then put your income into the Miller Trust and you now qualify. So a really good question that I don't have the answer for is why have an income cap? The cynical side of me thinks it's to mess people up, get them confused, and the state gets out of paying for care that it otherwise would have if the person would have done the Miller Trust exactly correct. I know that's cynical, but I can't come up and actually no one with the state has been able to explain to me why they have a income cap, primarily because they don't do it. It's the office or the legislature, someone else does it beside them. They're like, I don't know, we just do it. Okay? It is used when someone's income is over the limit, and that limit's about $2,200, $2,300. So if your gross income is over that amount, the state will say you do not qualify for Medicaid. However, nursing homes cost way more than that. So therefore, if you're over the cap but you can't pay fully for the nursing home, then you're stuck. Well, this guy named Miller in Colorado, mid-90s, late 90s, went to court and said, Judge, that's me. I make too much to qualify under the income cap, but I can't pay for the nursing home, and I'm otherwise broke, so I need your help. The judge in that case said, okay, fine, we will create a irrevocable income only trust so that you can put your income there. Since it's irrevocable, you can't change it, and it's the beneficiary of that trust is the state. So therefore, you don't control it, you don't benefit from it, so it's essentially gone. It is not in your state anymore. It is not something that will cause you to be disqualified. So therefore, once you're asset qualified, now income is a problem. You do the Miller Trust and you can therefore go on to Medicaid the next month. Okay? So that's basically what it is, how it works. Now there's a huge amount of discrepancies, and technically the federal law says the income that you put in there comes out of your income amount that you report to the state. So therefore, if you just put enough in there to get you under the limit, you're now qualified. So some goes in the trust, some doesn't. That's what federal law says. Some states, and the two that I practice in, Arkansas and Oklahoma, both have this strange rule that says all income has to go into the trust, and if all income doesn't go in, you don't qualify. I think that's too strict, but they didn't ask me. So in those states, and you have to be careful if you are watching this, in some other state besides Arkansas or Oklahoma, you need to check with your attorney who's doing this for you, or the nursing home or whatever, to see, do I have to put all income? Because if you do and you don't, you will be disqualified. I had one case where they did not put $19 a month into the Miller Trust, and that caused them to be disqualified for 6 months. The nursing home was about $6,000 a month. Do the math. 6 times 6,000 is $36,000 the state did not have to pay because these people did not put in over 6 months $120. Infuriating case. We fought it and we lost. Okay, so just understand they are serious about it, that if you're in a state that requires a Miller Trust and you don't do one and appropriately fund it, you will be disqualified. All right. So it's only done at the time that you need care, and you have to do it correctly. And I would highly recommend that you get with the nursing home and make sure they really understand, or get with an elder law attorney to really make sure that you do it correctly and that you fill everything out. And it's not just the document. The document's easy. It's a fill in the blank form that you do. It's carrying it out and the functioning of this trust. That's what gets difficult, and that's where people mess up. So I do recommend that you hire an attorney to at least set this up for you and explain to you how this works. Okay? I hope this helps. If you have questions, please email me at todd@elderlawinabox or at todd@toddwatleypa.com, and I will answer those questions and hopefully help keep you out of trouble. All right, thanks.